in the matter, my lord, I had moved it during the vacation. It relates to Neet undergraduate admissions. The counseling is scheduled day after tomorrow.
Mr. Counsel, we wanted to know whether that matter was taken up or some other matter was taken up.
Another one.
Whether there is any order passed by the Supreme Court.
I'm obliged, my lord. I have verified it, my lord. 7 high courts, an issue of 7 high courts, excluding Odisha, are pending before the Supreme Court, my lord. I've got a list of the high courts.
Mr. Is there any order passed by the Supreme Court that no high court should entertain any writ petition in relation to this test? This is what we wanted to.
There is no such order, my lord. The order relates to particular high courts, particular writ petitions, my lord. Nothing specific to Odisha, and the issue raised in the Odisha writ petition is very different from,
We understand that.
but there is no
But
such order.
the test is one. So who is appearing for the other side?
My lord, Mr. Bhutta is there for the Union of India. I've informed him.
Please inform him, please inquire, please. Sir, we have missed to read the order properly. Otherwise, we are under this impression
Hello.
that the Supreme Court has observed in one of its orders that no high court shall entertain any writ petition arising out of that NIT.
Well, may I then just pray, if your lordship can have the lordship has a busy day today, my lord. May I have your lordship's indulgence to have the matter tomorrow early on board?
We will see. If you make a mention tomorrow, if the matter is urgent, we will take up.
It's on today's list, my lord, item 55.
All right, we will take up the matter at 2.
I'm deeply obliged. I'm deeply.
May I be,
Form.
I may be pardoned, my lord. I may be pardoned, my lord. In item 38, it is a very urgent matter. After some date, the matter will be becoming infructuous, my lord.
What
Last
is the
occasion,
matter?
my lord, regarding this writ appeal is directed against my lords on the single judge, wherein the matter, although was matured for a final disposal, without
Again.
My lord, matter is that we are given promotion as back in 2018. Our promotion was challenged in a dispute case before the opposite respondent.
It is not an urgent matter.
Pardon, trace content matter.
Yes.
Trace content matter.
It will take an objection.
My
You
lord,
are
it's
not
a
required to
writ
make a
appeal,
mention.
my lord. It's a writ appeal, and your lordship have the extra query regarding applicability of CCA rules instead of police and others. Kindly take up.
We don't know. Or we don't know who will address the court.
That's fine.
Who will address the court? In fact,
Mr. Mahanti, you have instructions?
Yeah.
No,
they were,
question.
the instruction, in fact, they were saying that the police manual will apply.
Yes, my lordship, may fix it to next week. I'll argue. I have also got the instruction whether PF in his matter, your lordship has asked us a question whether that CCA rule or PMR is applicable in view of that rule 2 of the CCA rules. I have got that instruction that PMR is applicable because the judgment of this honorable court is that, and this is special statute, and in view of that special statute, PMR is applicable. I'll give that judgment. Your lordship may fix it next week.
Give your slip, we will see.
I'll argue.
I remember electricity case matter. Electricity case matter. I am contacting the case in person. For hearing the case matter, I am filing.
What is this? This is writ petition.
Case number, what is the case number? Single bench, division bench, can you? Challenging electricity dues,
It's a division.
then which bench electricity?
For ordinance, I am.
How is this a division bench matter? How do you say that?
Subject matter, jaldi tell. Jaldi. Whose order has he challenged, Mr. Pal, find out.
It's a matter of 2014, madam.
No, but final disposal, because there is a bench for orders passed by the OERC, grievance redressal forum and ombudsman. So what is his matter? He will have to-
Anything is, it is the only the opposite party is the TPD's CODL.
So you may have to make a mention before another division bench, DB3. All right, make a mention there and
Third floor.
and why are you are, Mr. You are an old man. You can take assistance of any counsel. What difficulty do you have?
In person, I am continuing the case.
You are in.
I filed the case matter in person.
But why are you not
Engaging a counsel.
engaging a counsel? Why? What difficulty do you have?
I'll manage.
He wants to do it himself.
No, you will manage, but the court may face difficulty. Court ର ଅସୁବିଧା ହେଇପାରେ ଆପଣଙ୍କର କେସ୍ ବୁଝିବା ପାଇଁ ସେଥିପାଇଁ ଆମେ ପଚାରୁଛୁ
ସବୁ ତ କରିଥିଲି ମୁଁ ନିଜେ କରିଥିଲି
ଠିକ ଅଛି ଅସୁବିଧା ହେଲେ ହବ but please help him.
My lord, in item 38, may I pray for
Malini, I mean, pardon. One matter was lordship disposed of on the submission, my friend, that is a covered, but it is not covered, my lord, it is a PIL matter. It was as if it was passed that it is filed by the leaseholders of the sanctuary. It is a PIL matter that is, some other order has been passed that is need to be modified. But the bench is your lordship and Justice Raman.
Because another matter you were doing, we have adjourned it.
Yes, that it is a similar matter. Here, my lord, I have given all the photographs.
No, that is a surprise because I remember signing the order, we have not disposed of. That is
No, that is another
Right,
matter.
alright.
This is another. Oblate.
Item number 1.
Judgment, we don't have much time today. On Monday, we will do that.
Mr. Das, you brought instructions, what we wanted.
My lord, pursuant to the direction of this honorable court,
Yes,
we have filed an affidavit that is on record. And there we have given the proceedings, the entire proceeding, after creation of the post, how they have proceeded. That is already there in the record. I'll just place that.
So is there some semblance of any selection or recruitment or?
No, only they have proceeded on the basis that since persons are continuing in the regional fine center, they were accommodated on the basis of seniority. That is the procedure adopted.
My lord, may I submit one thing, my lord? Only from the affidavit of the government has filed an affidavit to lordship of para 4, that initially the appointment was made, taking into exigency, my lord, that language that the regional spinal injury center RSI was established in 2001, para 4 of the register.
Please try to appreciate two aspects.
My lord.
One, your is not the only case which the court is required to hear. We have other cases also.
Yes.
to do. We have heard you already. And you cannot dictate the judgment.
No, my lord.
The judgment will have to be dictated by us.
Yes.
All right. So please don't disturb anymore.
Only one para, my lord. Only Monday.
Item number 2.
Lord, in item number 2.
Supplementary.
Item 2.
In item 2, on last occasion, I have made a submission that we have submitted the pension paper on 6/5/2024 to the AG, my lord. On 4/5.
For respondent to, I am appearing, my lord. We have, after receiving the pension paper, we have asked for some clarification on yesterday date. And the clarifications are before lordship. Soon after the clarifications are given, we receive the clarifications and everything will be done, my lord. Your lordship,
Yes, please for the petition.
Respondent number 1,
Whether you have received everything.
nothing in this.
No.
Only 2 months paid, the provisional pension, 24,000. Nothing, except that nothing has been paid to the petitioner.
I am clarifying. We submitted the pension paper to the AG on 4/5/2024. Final pension is to be sanctioned by the AG. Now, after 2 months, he has come with a letter on 3/7/2024 saying that these are the deficiencies, you comply it. So this was letter issued on 3/7/2024.
What are the deficiencies?
That they have approached, that, may I read my?
That main malady deficit.
What are the deficiencies?
Deficient outcome of departmental proceeding initiated due to the conviction and imprisonment of ex-government servant as ascertained from W number 439 of 2024 was not recorded in the service book. Attested copy of the final order of departmental proceeding may be furnished. The last pay of the deceased government servant was mentioned in page 14 of the service book as rupees 275 under the pay slab of rupees 255 to 360 with effect from 30/12/1980. Which remain unaltered as on 17/6/1985. Page number 20 of service book and up to date of death of ex-government which needs clarification. Here the ex-government servant expired on 29/2009, reason for non-reversion of his pay under 5th pay commission with effect from 1/1/96 and 6th pay commission with effect from 1/1/2006 and noting in the service may be furnished. The PSA has sanctioned provisional pension at the rate of 8,300 in OCS pension rule part 2 with effect from 21/9/2009, whereas minimum family pension payable is only rupees 3,500 per month up to 31/12/2015.
Better if he continues this provision.
These are the objections they have raised, so we have to comply.
And what about his provisional pension?
We have that has been released. That has been released. It is
Only 2
admitted
months provision pension has been released, my lord. 12,000.
after order of
12,000 24,000 ଖାଲି ପାଇଛି 2 ମାସର।
12 na 6.
No, 12,000 2 ମାସର।
Okay.
Ah,
Here the one query they have raised is minimum is 3,800.
Let them calculate.
You are getting provisional pension.
3,500. That will be revised because it has been
It will not
granted
be
in.
devised.
It will
We
be
have mentioned that
revised because we have granted provisional pension for
All
2 months.
So all those are not there in the service book, so they want updation.
Yes,
So
yes.
do it fast. You have to do it.
Yes. They have
This was communicated just yesterday.
That's all
Yes.
right. But
We are sent by mail to collector yesterday, my lord. So now my lord,
I was talking with the collector just morning, my lord. He said he has not received any information. I have also instructed him to collect the data from the AG. Why that has not been sanctioned? I have received it today. I have talked with the collector today morning, my lord.
No, why did it take it 2 months for you to raise these objections?
My lord, I took because on last occasion I was in the court. Personally, I was sitting in the court. Then I got a writ appeal copy from myself from the petitioners council. Then I sent and get it done, my lord. These things.
Otherwise they would
It
not
should
have.
have been. It should have been. But for some reason that I have not inquired why it was delayed. But so after receiving the pension paper, why there was a delay of another 1 month, some days. On 4/5, they have. It must be received some days after.
Uh, the state government, the pension sanctioning authority had sanctioned family pension on 4/5/2024.
No, my lord, 4/5/24, they have sent pension paper to us.
what is theirs?
Family pension.
It has been sanctioned.
Family pension.
Read your.
Family pension is.
Sanction payment of family pension in favor of the respondent on 4/5/2024. And the sanction order was communicated to the office of the Principal Accountant General A&E, Odisha, Bhubaneswar. Full stop. 2 months thereafter, nearly 2 months thereafter, on 3/7/2024, the office of the Accountant General has communicated to the collector, come district magistrate Bargarh, comma, who is the pension sanctioning authority. Certain defects, certain deficiencies in the pension papers for authorization of family pension. Full stop. List this matter on 2 weeks. Full stop. The said communication has been produced before us by the learned counsel representing the accountant general. Full stop. List this matter on 2 weeks. Who authorizes the pension?
Now the collector will make the AG will authorize.
Authorize. AG
They-
has it.
They will give the
Whether AG or principal AG.
principal AG. Officer
Principal AG.
principal AG, the accounts of
Let Principal Accountant General Odisha file a personal affidavit stating as to why it took nearly 2 months for the Office of the Accountant General to point out the deficiencies in the pension papers. List this case 2 weeks within first 5 cases. The court would expect the Office of the Principal Accountant General to take a policy decision fixing a timeline within which the pension papers should be processed after sanction by the pension sanctioning authority.
Your lordship may say within 7 days the collector will comply.
They will do whatever. You file affidavit first.
I will say.
You will do whatever is required to be done in this case. But you file an affidavit. Then why do you take 2 months? And the affidavit will have to be sworn by him, no other officer.
Item number 3.
Lordship has directed by order to 27/6. By order to 27/6, my lord is directed on State Council take instruction and file an affidavit regarding filing one affidavit. Regarding filing of one affidavit. That one regarding auction settlement.
So Lordship, we're filing the counter affidavit during the course of the day, Your Lordship. Today itself it will be filed. It can be put up on Monday, Your Lordship.
It will come on Monday.
I have filed an application for intervention. I am one of the successful person whose technical bid has been accepted. So may say a copy may be served on me in order to assist you.
Have you served a copy on him?
Yes, I am serving.
You have served.
Yes.
You have served. You have.
In course of the day, I am serving.
So if after you serve, you will serve.
Yes.
List this case on Monday so as to enable an AGA to file an affidavit. Counter affidavit or what?
Your Lordship will bring in the facts, Your Lordship, as to why it was rejected and the discrepancies in his application, Your Lordship.
What is the IN number?
It has been filed today, it has not been numbered. I'll serve in course.
Do it. We are not saying anything.
May I pray, my lord, the auction may not be finalized.
That is there, Your Lordship. The interim order is there. It is subject to the result of the writ application.
No, sir, that is no, sir. My lord has only issued.
No, subject,
No.
because we were saying subject to, you said that will cause difficulty. That is why
Oh, yes, ma'am.
we are waiting for their counter.
Yes, please.
Monday. it will-
Test admission item number 4.
May I please? Your Lordship? The Shopfield prefers challenging the judgment passed in WPC number 14728 of 2013, Your Lordship, in allowing this writ application and further directing the CDPO, Your Lordship, the annexure A by 1 running page 27, Your Lordship, directing the CDPO Muribal to issue necessary order to engage in favor of the petitioner in the writ application as Anganwadi worker of Dungriguda, additional Anganwadi center without any further delay and in case within in any case within 4 months from the date of communication. This appellant was appointed as the Anganwadi worker in that center, your lordship. The appointment of the appellant of this appellant, who is the private opposite party in the writ application, has been cancelled by the honorable single judge, your lordship, and which has been confirmed by the ADM, your lordship, in appeal case number, your lordship, 11 of 2011. As per the direction of this honorable court, that appeal was disposed of under annexure A by 2 from running page 28, your lordship. This appellant's appointment has been confirmed as per the order dated, your lordship, 24th April of 2013. That has been challenged in the writ application, and in the writ application, the order has been quashed, your lordship. On the findings, your lordship, under annexure A by 1, running page, your lordship, 23, para 9, your lordship. Para 9, 10.
Only the
Only ground that both the certificates of 7th class has been taken into consideration, and in class 7, that honorable single judge found that
the private respondent was more meritorious than you. Is there any doubt?
that has been dealt with by the law.
C is code 57, you is code 39.
Your lordship, why I am submitting before lordship? 2 certificates has been given. The 7th class certificate of 2 certificates has been given. In one certificate, he has less mark. And in other certificate, which has been submitted in later stage of the cut-off date, that is in more mark, your lordship. That is doubtful. The ADM also found that. In his order, the ADM also found that the 2 certificates have been found. And it is mandatory to read and write Orissa. She has been failed in Orissa.
That is not mandatory.
No, that
This
is
is what the court has
circular.
said.
No,
But there
not-
was no such stipulation in
But
the
it is
advertisement.
doubtful. It is doubtful that 2 certificates have been filed. One is less than that of this writ application, and other is more than that. The second application after cut-off date. That is the findings of the learned ADM. Your
No,
lordship.
but is it not correct that the first certificate was cancelled because it was giving the wrong marks and the second one issued subsequently, but
No,
relates to
that is
the,
not the findings of the ADM, and that has not been done by the CDP.
what about the finding of the High Court?
Findings of the High Court is that she has secured more marks, and the second one is accepted.
No, we are not interested.
So also the certificate of matriculation, which is mandatory, is out of state. That also CDPO confirmed that the certificate submitted, the HSC certificate is equivalent. On that point of question, I have nothing to say. But in the second point of question, that the 7th class certificate has been submitted by the writ petitioner twice. One is less mark and other is, that is also doubtful. The findings of the learned ADM.
On the basis of doubt, we cannot interfere. We should not interfere.
But there is no clarity from CDPO, from the order of the ADM, that either the certificate are fake or the original. There is no clarity. So also the findings of the...
On the basis of suspicion, whether she should have been terminated.
Till date I have not been terminated. Because there is a 4 months time, till date I have not been terminated. But my appointment since 2010, your lordship, since 2011, your lordship, that has been confirmed by the learned ADM is order under annexure AY2. Only simply saying that Odia has to read and write, that my appointment has been cancelled. The annexure 2, AY2 has been quashed, your lordship, by the honorable single judge.
Where is the order?
Order is under annexure A by 2, single bench
Where is
order.
the order of the ADM?
Under annexure A by 2, your lordship,
A by
running
2?
page, your lordship, 28. From running page 28, your lordship. The findings of the learned ADM is very clear.
What is there?
I'll go to that, Your Lordship. Running page 30. Your Lordship, learning page 30. The respondent, taking into consideration the facts and circumstances of the case, peruse the documents available in the record and argument led by the learned advocate. Admittedly, the CDPO Moribal has issued re-notification by notification dated number 346 dated 3/6/2010 inviting application from the suitable ladies candidates living in service area of concerned Anganwadi Center as per the observation of the appellate court in the order dated 5/5/2010 passed in Miss Appeal number 22 and 23 of 2009. As per the above notification, 3 candidates including appellant as well as respondent were filed application along with the requisite documents as per the norms of notification for the post of Anganwadi worker of Dunguriguda Anganwadi Center. The selection committee, Muribal, has made observation in the proceeding dated 6/7 of 2010 in respect of Dunguriguda Anganwadi Center that out of 3 candidates, Jayanti Bera belongs to
Sir, please come to paragraph
Badudara,
31.
which is other than the service area of the proposed center and thereby this lost for candidature for the post of Anganwadi. Secondly, the appellant Kemoti Kasrel had submitted the HSC certificate issued by the Noida board and thereby the committee sought for clarification from the government regarding acceptance of this certificate.
Mr. Counsel, where this is the order which was under challenge?
That was challenged in the writ application.
That was in the writ petition.
Yes, my lord.
In the writ petition, this order was under challenge.
This order was cancelled.
So where is the finding that because she had submitted 2 certificates of standard 7, therefore her candidature was rejected? Where is that?
This is in this next para, Your Lordship.
Please read that next paragraph.
Yes, the appellant filed a list board of conducting 10 plus second.
Which paragraph?
That is, Your Lordship, running page 31, Your Lordship.
Yes.
Running page 31, first para, Your Lordship.
Yes.
The appellant filed a list of boards conducting 10 plus secondary examination declaring equivalent to the high school certificate examination conducted by the Board of Secondary Education Odisha, wherein National Institute of Open School is found placed in serial number 27 in the list. On the verification of the certificate of the appellant Kemati herself, it is found that without Odia subject, she has been passed the examination. The certificate of standard 7 produced by the appellant, wherein the appellant filed in Odia subject by securing 20 marks out of 100 marks. On the other hand, respondent has secured 30 marks out of 100 in HSC examination.
So this is the reason. And this reason has been found to be incorrect.
I am the respondent, my lord. They are in the appeal. I am the respondent.
See, this order, no, repetition was allowed. The repetition was allowed. This order was set aside. This order has been set aside.
This order has been set.
This order has been set aside. So where is there in this order that she had produced 2 certificates of having passed standard 7?
That is in the discussion of the both
Discussion is
appellant.
material. Reason is here.
Yes.
And Odia is not required.
Odia is required, but read and writing.
Huh?
Not mandatorily to be passed, but read and writing. That is the clause.
So a certificate
Alright.
is not required for ODI.
Read and writing.
Alright.
It is mandatorily not to be passed, but read and writing.
So the learned single judge has rightly held that they see the reasoning, the certificate of a standard 7 produced by appellant, where appellant failed in Odia subject.
That has been considered because he has been appeared in Odia.
This is the reason why the appeal was dismissed. This is the reason recorded by the appellate authority.
My submission before Your
Sorry.
Lordship.
The
Your Lordship, in the annexed A by 1, the
Mr. Counsel, please show us one reasoning assigned by the appellate authority or whosoever is the authority for rejecting the claim of the writ petitioner on the ground that she had submitted two certificates of.
Yes, that is also the findings of the Honorable Single Judge, Your Lordship. I am going to that, Your Lordship.
The
Your Lordship.
finding, but what is the?
Yes, I am going to that. The discussion is under running page 24, Your Lordship, para 10 of the single judge order, Your Lordship.
Para 10 is regarding reading and writing.
Yes, reading and writing, and two certificate also that has been found, Your Lordship. That is also decided therein. In the running page 25, Your Lordship.
Not there.
In one, he has secured 18 marks, in other, she has secured 20 marks, Your Lordship.
All right.
So that the learned single judge has said that need not pass. That
Yes.
she studied means that means she knows reading and writing. But that is
But the
the
consideration of Your Lordship,
That is their
submission of two certificate has not been taken into consideration.
All right. Dismissed with light orders. Dismissed. Right.
Item number 5.
May I please, my lord? My lord, yesterday, your lordship had raised a very valid observation that whether I have filed this, I have challenged only the review order of the review in the review petition to circumvent the limitation question, your lordship. On that point, my intention was never to circumvent the limitation clause, your lordship. The original order was passed on, your lordship may kindly peruse, on dated 29 at page number 154, your lordship. The original order was passed on 29/4/2024. Your lordship, the review petition was filed in 10 days time, that is on 9th May 2024, your lordship. And the impugned order was passed on dated 19/6/2024, your lordship. And this
No, that is not the question. The question is that if there are two orders, one passed in the writ proceeding and the other passed in review proceeding. When you are challenging two orders, both the orders were passed in separate proceeding. So whether you can maintain one appeal against both the orders, that is the question. Because when we consider the correctness of this order 19/6/2024, the grounds are different. When we consider this 29/4/2024 order, the grounds are different.
My reason for not challenging both the orders and challenging only the review order is that they are one and the same. The order has both the orders are one and the same in terms of their tone, tenor, and substantial lordship. That is the reason I didn't challenge both.
Appreciation of the judgment passed in review. The appreciation is different because there the scope is narrow.
My lord.
See, when we consider the order passed in review jurisdiction, correctness of that, then our scopes shall be limited because the scope of the review court was also very limited. So to that extent, whether there is an error or not, suppose on that ground we may dismiss your review application, and we don't know whether we will allow your
writ application.
Writ petition. You have not challenged that.
Let me place the conspectus of the case. If your lordship desires, then I will amend the.
We don't desire. We want to know from you.
That
we know with this we want to learn from all the members of the bar.
My lord.
That what is the system here and what should be the system.
My lord.
And the system not based on perception, not based on general knowledge, not based on the statutory provisions.
My lord. My lord, may I place the conspectus of the case? That from that it would be amply clear that there is no requirement, according to my limited understanding, to challenge both the orders. Because your lordship may kindly consider the original order. In the original order passed by the Honorable Single Judge, it was passed only on the mere mention that I joined the post of transfer. And on
this order was passed 29/4/2024.
My lord.
You have challenged that order also?
My lord, it gets challenged in this order by challenging the review order in the review
No,
petition.
no, this order you have challenged in the present appeal.
My lord,
So whether your appeal is barred by limitation?
no, my lord.
Why?
Just that's what I was saying. 24th May, 24th April, the order was passed, and I filed the review petition in 10 days time.
24th April.
Forget review petition.
My lord,
You are challenging an order passed on 29/4/2024.
my lord.
In an appeal preferred on when?
On 27/6/2024.
27/6.
6, my lord.
So whether it is not time barred?
That in that sense, it would be time barred, but
In that sense, you will be time barred, then how can we entertain that?
my lord, that is why
Your appeal
My lord.
against the original order, how that can be entertained?
my lord,
That can be entertained. There is provision under the Limitation Act also.
my lord.
But
that-
you will have to explain that.
My lord, that is what I was with your lordship's permission. If that requires, I'll file a modification petition to that extent.
We don't know, we will decide this.
Modification or condemnation?
Along with modification, because that since I have not challenged that order in specific,
You are not challenging that order.
that order I have,
Very good.
my lord.
Don't
So,
challenge.
My lord, I have just challenged the review petition because both the orders are same in terms of tone, tenor, and substantial lordship.
Sir, when review application is disposed of,
lord.
dismissed,
My lord.
then both the orders are same.
My lord, that is the reason, because the original order was passed on the mere mention that I have joined the post of transfer, and because there was a point of law which I brought to the kind of knowledge of the honorable single judge through the review
Probably we
petition.
have not been able to convey what we wanted to convey. All right. Let us see the impugned order.
My lord. My lord, the impugned order, the review petition was filed bringing to the knowledge of the honorable single judge that by mere joining the post of transfer, the writ petition may not be declared infructuous, because there is a division bench order of the esteemed apex court, which I brought before the knowledge of the honorable single judge. But without considering that on the
So you could have challenged that order.
my lord.
Yes, so is for the state.
My lord, lordship may kindly have a glance to page 154. That is the order which was originally passed in the writ petition.
Yes.
Lordship may kindly have a glance.
Yes.
It is contended by Mr. J.K. Lekka, learned counsel for the opposite party number 3, that the petitioner in terms of the interim order has already joined in this service. The said fact is not disputed by B.K. Mishra, learned counsel for the petitioner, since in terms of the order, the petitioner has already joined in his service. In the meantime, the prayer made in the writ petition has become infructuous. In view of the same, the writ petition is disposed of.
Why? Oh, if a person challenges the order of transfer,
Yes, ma'am.
and he joins in obedience of the order of transfer, so the writ petition will become infructuous.
But if he doesn't join, then you start proceeding against him, then
No matter. In fact, since he had challenged the order of transfer in the writ petition,
no, that I
at
have
least
understood.
he
but-
could have sought for an interlocutory order from the
So
honorable
interim
court.
order was in decline.
Yes,
Interim order was declined.
Decline.
yes,
And therefore he had no other option but to
Join.
join that.
yes.
But can he not maintain his writ petition despite that? We'll see. issue notice.
That is one. Number two, whether he has a right.
No, that we will consider later.
Yes.
His writ petition has been disposed of as infructuous only on the ground
That
he joined.
Yes,
So that is the question
that is the only
which
question.
requires consideration.
Yes.
Issue notice.
But even assuming for the sake of argument, my lord, if my lord gives a finding that yes, the writ petition should not have been rendered infructuous, and the order passed in the review proceeding is contrary to law, and that is set aside.
No, what we will do, we don't know.
My lord, it is on assumptions. That is, then the matter relates back to this final order, which is not the subject matter of challenge in the present writ appeal.
We will see what can be done. In the meanwhile, he may also do something.
What he was saying also, the review order is exactly the same. That also not gone into merits regarding that question of
See,
the
yes, the review application has rightly been dismissed.
Yes.
All right. Because there was no the correctness or otherwise of this order, the order passed in the writ petition could not have been gone into in the review proceeding. So we may sustain this order, but we may interfere if he challenges. We don't
Yes.
know. Prima facie, we are of the view that only on the ground that transferred person joins the post, his writ petition cannot be held to be infructuous on that ground. There are so many reasons. Suppose if transfer exigency of service, all right. But if the order has been issued by an authority not competent to do that, if the transfer order has been passed contrary to the rules, then also the court may intervene.
Provided he has made out a case in that way.
Provided
Yes.
it could have been recorded that he has joined, and even otherwise there is nothing. That the matter would have been different. All right. Some private respondent is also there.
No private.
Must be there. So he must have been transferred in place of someone.
No, I am not that. No private respondent.
Then the writ petition should not have been entertained.
No, my lord, the transfer petition can be challenged only on two grounds. That if it,
Mr. Counsel, you were transferred
my lord,
to a place.
my lord,
Whether someone was already working against that post.
my lord, that is not my subject of contention, your lordship. My lord, I was transferred before my tenure, before time, under two grounds. That there was malice of facts and malice of law. The grounds it was stated that I'm being transferred on administrative ground. No law was followed to.
No law is required to be followed in the
in an administrative ground. And the facts that were mentioned.
The only point which is available in your case is whether because of your joining,
My lord,
the writ petition ought to have been
my lord.
held to be infructuous. So at this point we will consider, otherwise transfer matters we don't interfere. Issue notice. So and so accept notice on behalf of the respondents. This matter on. So affidavits are there.
Affidavits are there.
No, writ petition where counters filed.
No counter.
And autonomous college will take notice. Accept notice for autonomous college.
Autonomous college notice has to go, my lord.
Issue notice.
Respond.
Yes.
Obliged.
Item number 6.
May I please, my lord?
Kindly see the order dated 27 June, my lord. There, your lordship directed my name to be reflected since the OP number 3 competent authority under the OPID Act is a party, my lord. And my learned friend has not yet served the additional affidavit on me. And in other connected cases, he has also not served the copy.
Yes.
That has already been served on the government. We may permitted to serve extra copy on my print.
When he is saying copy has not been served on him, whether it is served on the government or not, how is it material?
I will serve it.
Yes.
Your Lordship, may reflect my name in all other cases.
Only in
Your-
one case his name has been.
Your all other cases also involving OPID Act,
You don't have to file appearance memo, not required.
not required.
Not required means?
Lord, I have been notified as a special counsel, so for the, and it was communicated also, it is notified in the Gazette.
So you can appear without wakalatnama,
Like government advocate, I can appear.
like government advocate.
Yes.
There is difference between government advocate and you.
Miller.
Or you are for OPED.
OPID, Miller.
OPID, what is this?
Odisha Protection of Interest of Depositors in Financial Establishment Act.
But appearance memo also not required,
Not
that
re-
like the central government council are filing.
No, like government council, I can appear. Not, no memo is required.
Have you examined the rules? High Court rules you have examined.
I place the relevant rules in progress.
You serve copies.
My lord.
My lord, I am appearing for Reena Mishra. I'm filing my wakalat number today.
For Reena Mishra in which case?
Appearing
9136
9136.
in one of
First
the
case.
case.
first case, let me see. What is this matter? We have not issued notice.
No, it is.
What is this matter, Mr. Nanda? Who is arguing for the petitioner?
My lord, I am.
Both of you together?
Mr. Nanda was arguing perhaps.
I am also appearing.
Mr. Nanda was arguing.
Matter relating to.
Your learned senior is?
How
MS
many
Sahu.
cases are there?
18 cases.
So what is the matter involved?
My lord, matter involved is the petitioner is a company. He has advertised for selling of plots and accepted money from different home buyers. My lord. That is not a home. Actually, that is a plot selling project. There are 5 projects. One of the depositors filed an FIR before the EOW, and the EOW subsequently lost 5 FIRs against 5 projects. And I was arrested in the year 2012. The Honorable Apex Court grant me bail on a condition that I have to deposit all the amount that I have taken from the depositors. Pursuant to that condition, I have deposited the entire amount before the Honorable Apex Court by 2016. And that has already been transferred to the Lord OPID Court, and the OPID Court has already released the amount in favor of ADM. And the ADM has issued advertisement seeking applications from the depositors. And the ADM has also verified those applications and already taken steps to refund those amounts with interest to those depositors. Notwithstanding that, the depositors are approaching the consumer forum as well as the RERA forum. My case is that since I have already deposited the amount taken by 2016, when the RERA Act was not come into force.
So you have come file these writ applications
My lord.
for us to restrain all others from filing any case against you.
In
because
other
that-
forums. In
On
other-
all other forums, because the OPID.
Anyone is free. To file any application, you can go and you can contest.
Then that I have contested and that has already been ordered against me, my lord.
And just one moment. In the first case, you challenged the order passed in the sumo 2 complaint case.
My lord,
So is it maintainable before the division bench? I think this is an assigned bench, Mr. Bhuya.
Millard, here my lord will see.
No. First, tell me that.
Millard.
whether it is a division bench matter or a single judge. Because order,
It will be assigning no single judge, my lord, because the order of the RERA has been challenged, my lord.
And there is an appellate authority of
Under
area that-
under the
on
statute.
that, in that case where I was appearing, your lordship has directed me to for a conciliation. The Mr. Tripathi for Oreda, he submitted that there is a appellate forum. But one thing I must recapitulate your lordship's memory. This was hard. I was appearing, Mr. Nanda was, your lordship has opined that whatever amount was deposited by you, that is a condition for grant of bail.
Yes.
By the Supreme Court. So for utilizing that amount for any other purpose, you have to take the permission of the Supreme Court. That we cannot sit over that. That was the opinion of the honorable. That's all.
On that ground, you are challenging.
My lord,
He
honorable
is saying
apex
that
court has
since I have
directed for
deposited the
disbursement
amount there,
that amount.
I cannot be compelled to return it to individual customers or consumers.
but what he is saying, Supreme Court has passed certain directions.
My lord,
Can we sit over that order and say that amount has to be adjusted here?
my lord, honorable Supreme Court has already directed to disburse the amount to depositors.
That was a condition for grant of bail only.
My lord, that is the entire amount I have received.
Maybe, but that is different. That is not that is not an adjudication on
Merit.
your,
No adjudication.
on all your criminal or
My
civil
lord.
liabilities.
Criminal case.
No, you can take a plea. That this amount I have paid. They deposited the amount, but this is not the forum.
My lord, because I am going to face many similar cases in many forums.
You may.
My lord, the matter is already under
So you
session of the
want
OPI
an
court.
order from this court that no one should file any application before any forum because you have deposited the amount.
And that is pending before the OPID court, my
Yes.
lord. OPID court is under session, my.
Will not do.
See, regarding order of RERA, why don't you follow the proper procedure? So one case will be there, thereafter that you can challenge, but coming directly here,
No, my lord, I have preferred an appeal that has been rejected due to non-deposit of statutory amount, my lord.
so that
That
order,
is, that is-
order, that understand, that is the problem. So that order you challenge, explaining what you are saying here.
My lord.
But once we entertain, everybody will come here. We'll open the floodgate. So that is what we are saying. You follow the proper procedure.
Actually, he has filed the case in the nature of PIL. Not,
This is not a
that
PIL, I am
law
speaking on protection, my lord. Because I have
protects
already
that,
deposited.
nobody should file any case.
I should
before
not
the
be-
RERA court or
I should not be
consumer
allowed to
court.
face.
If we pass such order, Mr. Council, people will laugh at us.
Yes.
Yes.
Your
So what
lordship
do you
may
want?
kindly take it on any other day, I can.
No.
My lord, at least one chance, my lord.
No chance. Not even.
All the cases are similar.
Because of the sister's intervention, we are the matter is being adjourned
My lord,
for a
obliged.
week. As requested on behalf of the petitioners, list these matters on 1 week within first 5 cases.
Your name, please. I don't think your name is there on record.
MS Sav, I have already filed the Bakara.
Okay, no, we litigated. MSR on behalf of Mr. D. Nanda.
Mr. You will appear or someone else will appear?
My lord.
In some cases, Devasis Nanda is on all the cases.
Yes, that is what I'm saying on his behalf.
From cost title, it seems.
On his behalf, we have heard him.
Yes.
Item number 7.
Yesterday, directed the Law and Council
Yes, my
appearing for the Union of India to take instruction about the NEET exam, my lord.
My lord, different set of cases have been filed for Honorable Supreme Court, and Honorable Supreme Court has been fixed this matter to 8th of July. And before, because there are 4 different benches where the matters have been, and one matter that is listed before my Lord Justice Vati and Justice Manoj Mishra on 26, it has been directed that whatever case has been filed by NTA, that will be remain state till this matter is decided. So if my Lord fixes this matter after
No,
8th
where
of
is that
July,
order?
my Lord.
Where is that order of Supreme Court? Do you have a copy of that order?
That is regarding NTA, my lord. These cases are by the petitioner. 2 issues have been raised. One, malpractice and irregularity. Here, the petitioner is raising that she is entitled to secure 630 marks instead of he has been awarded 284 marks. If at all re-examination or re-evaluation is to be directed, then this matter will cover under that. This matter and another matter, item
That
55.
is why we're asking if you give us that order, we can see.
My lord, that order. I'll just give a printout, my lord. We'll sign it.
Another matter was there today. Have you posted it to Monday? What a fila? Or he was mentioning 53 or 56. Urgent matter. We have kept it at 2, I think.
55.
That is the one.
Right.
So your examination matter,
55.
2 p.m.
Yes.
We'll take it up at 2 p.m. There's another matter.
My lord,
Where-
item 55.
You're there, appearing there? Up there.
One of the cases.
All right. That 55, 56, whichever, that one.
55. All 3
right.
matters are there in the
So
item.
the council, we've asked him to come back at 2. So both of these matters, will be took. Meanwhile, you give us that judgment. All right.
My lord.
Yes.
Item number 8.
Oh, you are there.
My lord,
Thinking dismissed once, again it will be dismissed.
due to non-appearance of my advocate, this case has been dismissed. I kindly pray for restoration and kindly pray fix one early hearing date.
Your contempt application has been dismissed.
Madam,
Who is for the other side?
When was that dismissed? File has been shredded. A private party. When was it dismissed? Kebe dismiss hela? Kebe dismiss heichi contempt ta? Subune? Contempt application ta kebe dismiss hela? Are
contempt petition टा केबे dismiss ହେଲା?
देखिए नहले कह देले.
And what was the order?
On 21/4/2016.
What was the order? Do you have? Can you see?
Original order again.
Original order.
Order. Where is that order? Order copy है. Order का copy है. Sports है.
Here it is, this council will not appear. It is not, I think, hard of hearing, another problem. Contempt ଟା କାହିଁକି ଫାଇଲ କରିଥିଲେ?
madam, ଓକିଲ କରିଥିଲେ ଆଉ ସେ ଆସିଲେନି।
ସେ ମୁଁ ଜାଣିଛି ସେଇଟା ହେଲା contempt ଟା dismiss ହେଲା ସେଇଟାର କାରଣ ଯୋଉ contempt ଟା ଫାଇଲ କରିଥିଲେ ହାଇକୋର୍ଟ ର କୋଉ ଅର୍ଡର ଟାକୁ ସେମାନେ ମାନୁ ନଥିଲେ
ମ୍ୟାଡାମ ସେଇଟା ଅଛି ଫାଇଲରେ
ଏତେରି।
2353 ପାଇଁ ନାହିଁ ସେଇଟା ନାହିଁ ଏଇଟା ନାହିଁ
ଆରେ contempt
Please
dismissal
step on
ଦରକାର ନାହିଁ ଆଚ୍ଛା here
step on by clause
Original order ଯୋଉଟା court ର ଯୋଉ order
ଅଛି
କାହିଁ ସେଇଟା
ସେଟା ମୁଁ ଜାଣିନି ଠିକ ଅଛି ସାର୍ ଆପଣ ନମ୍ବର ଟିକେ ଆଗେ ଜାଣିପାରିବେ
ଗୋଟେ ଛୋଟ ଅର୍ଡର ଟେ ଅଛି compliance affidavit ବି ଅଛି
state is a party man.
ହଁ the opposite party is the OES service ଅଛି କହୁଛି
Odisha education.
inspector of schools Sundargarh circle second copy ଅଛି ଦିଅନ୍ତୁ। ଯଦି ଥିବ we can see otherwise you can see if anything can be done
That are the direction LRC
उसको बोलो
that 16/10/2009
कि
to conclude the
because
proceeding.
वकील नहीं किया है किस तरह के अनुसार प्रॉब्लम and he was this order was passed in 2009 with this to conclude the proceeding and take decision for matters with reference to decision
LRC will looking at that complaints.
you have to challenge that
LRC will looking at that complaints.
Sorry?
LRC will looking at that that order was to conclude the proceeding. In that complaints affidavit, it has been stated you are dismissed from service, so that proceeding is concluded. On the basis of this submission, that contempt proceeding might have been dismissed.
कुछ बोल दो कुछ नहीं हो सकता है
So you advise him what to do इसमें कुछ नहीं होगा
तेरे किसी हबनी आपको यही गला से जो डिसमिसल ऑर्डर था है कि अपन जो चैलेंज करियो चाहिए चैलेंज करियो तो contempt proceeding रे किसी हबनी
the petition saying
लेकिन चंदी से
petitioner
neither I have received nor
eight dismissal
no I have not received or not 21/4/2016 law with the contempt of each
the order was passed on 21/4/2016 the contempt was dropped.
all right we are passing on
final order will grant him liberty to challenge that will serve the purpose right that final order has been passed na in the proceedings
yes dismissal order has been that has been annexed to that so compliance agreement also you can see it.
no will grant him liberty to challenge
yes
that order.
yes that I am saying so but he is saying that order has not been served to him.
The petitioner has appeared in person. Stop.
अच्छी ना limitation अच्छी अच्छा 218 कौन 218
challenge
we condone the petitioner had filed a writ application giving rise to WPC number 12445 of 2009 with a grievance that no final order was being passed on his reply to the so-called notice for termination of his service on the ground of unauthorized absence. Stop. In that background, this court, by an order dated 16/10/2009, had disposed of the writ petition with a direction to the inspector of schools Sundargarh Circle, Sundargarh, to conclude the proceedings and take a decision on the notice to the so cause which was brought on record by way of Annexure 6 to the writ application. First off, alleging non-compliance of the said order dated 16/10/2009, the petitioner filed a contempt application giving rise to CO 3 of 2010. First off, in the said contempt application, a compliance affidavit bringing on record an order dated 8/11/2010, bringing on record an office order number 7709 dated 8/11/2010, passed by the Inspector of Schools in compliance of this court's order dated 16/10/2009. Ordered for dismissal of the petitioner from service. Stop. Next. When the contempt application was taken up by this court on 21/4/2016, because of non-appearance of because of non-representation on behalf of the petitioner, the contempt proceeding was dropped. Stop. Next, this application has been filed seeking restoration of the contempt application, that is CONTC number 2353 of 2010 to its original file. Stop. This application has been filed in 2022. 22.
Yes.
Stop. We ignore the delay in filing the present application for restoration. Stop. However, we, after having seen the records of CONTC number 2353 of 2010, we are of the considered view that no case of deliberate disobedience of this court's order is made out, and therefore no purpose will be served by directing restoration of CONTC number 2353 of 2010 to its original file. First off, the petitioner in person has stated that he has not received so far the order of dismissal which was passed in the year 2010. First off, we are not inclined to go into such aspect in the present proceeding. Stop. We make an observation that we deem it fit to observe that the petitioner shall be at liberty to assail the order of dismissal passed in the year 2010, if according to him, a copy of the order was not communicated / served upon him so far. Stop. This application stands disposed of in appropriate forum. Yes. Okay.
So you have been given liberty to challenge that order of dismissal, all right? Yes.
Item number 9.
Although if you have not received the order, then only. If there is some evidence that the order was served upon you, then you cannot challenge after 14 years.
Yesterday, this matter was before my lords, and lordship has instructed me to request
That's
Mr.
a
Patra.
service of copy where you are
Mr.
facing
Patra,
problem.
I have requested him, he has appeared.
I have instruction to appear. I have received the instruction of 126 persons. There are 945 persons.
Mr.
Yes, ma'am.
How could this application be filed without any address?
Yes, my lord, address was there.
Where?
Address, your lordship may kindly see the petition. While they are working in the office, they are filed for regularization.
No, where is that?
Yes, your lordship may kindly see.
Page?
Okay.
9.
At page 224.
224.
Yes, my lord. Lordship, what it is?
Yes.
224.
Yes.
After 945.
Huh?
After the applicants number 945, below applicants number 1 to 1 such and such person are presently working under the Warsaw establishment of executive engineer oversees economic cooperation funds. Next
That
page
is the
also.
address.
Because they are working there under the offices. And your lordship, just I am while the case was disposed of, direction was given to file independent representations. While I would file representations indicating the detailed address. Why I am showing so much detailed address?
Mr. Counsel, in this writ appeal, how notices can be issued to them?
My lord, notice has not been issued by this honorable court. This honorable directed to file the requisites, but the executive engineer has issued the notice in the name of the High Court. We have already received the notice from the chief engineer. All the addresses are there with them.
So you have received?
Yes, some of the
That means notice is sufficient. They need not take further steps because the executive engineer is taking steps for service of the notice.
He could have filed the address along with the requisites, but he did not file. I am not calling up to that aspect. Only 126 persons have received the notice. Well, I have also instruction from the 126 persons to appear in the case. And the notice they have received from the chief engineer, HRD, T&CD. In the meantime, so also my instruction that some more persons will come in within 2 to 3 weeks. So I will appear for all those who will come to us, because out of 945, near about 200 have already been regularized, and many of them have died. So those who are surviving, they are coming. They are remaining in different places. And in the meantime, after retirement, 20 years have been passed. So they are also getting information. They are coming now to 100, near about 150% have come. Well, by last Sunday, and also instruction that they are searching for other persons. And in the meantime, 200, near about many persons have been regularized.
What is your name?
Sadashiva Patra. Sadashiva Patra.
Mr. Sadashiva Patra, and counsel has informed this court that how many respondents are there?
945.
Out of 945, 200 already, near about 200 have been regularized. So they have no interest. Must not have no interest. And many have also died in the meantime.
Yes,
945 private respondents. He has received instructions to appear on behalf of nearly
Kete by appear instruction
126.
already received.
126. So he submits that he is likely to receive similar instructions from other respondents, the rest of the respondents who are alive. No problem. We'll list this matter on 2 weeks. No, we have been informed that notices have been served upon the private respondents through executive engineer.
He's saying
Yes, my lord. Your lordship, through chief engineer.
Through the chief
One of the notices there. I have accounting. Your
All right.
And my lord, in the my
Chief
content
engineer, whatever says chief engineer means what? Chief engineer or what?
Chief engineer, office of the engineer in chief, water resources, Odisha, Bhubaneswar.
Water resources.
Opposite no. And in the content application also, we have a file content application. Detail address was given. They have also the addresses.
It is all right, but they are challenging the order when the addresses are not there.
We cannot change the court title as described in that way in the writ appeal.
So if you are conducting, you are conducting contempt application on behalf of how many persons?
Those who are filed their representations, person to this honorable, I am going to 234. 234.
Only one contempt application, others are also there.
Only one contempt.
Because Mr. Ratha is appearing in some
Sorry,
contempt
contempt application, another application also there. 2 to 3 applications are there. Those who came later, they file separate application.
Item number 10.
Since you are aware, you instruct, otherwise we will say notice sufficient and proceed.
That's why I had instructed, after coming to know that I have instructed to collect all the information. Lord, the fixed it on 2
weeks.
Item number 10.
How much time will you?
3 weeks, within 3 weeks. As you can, a number of persons are there, they may come in the.
All right, all right.
In item 10, my lord, your lordship has issued notice on 9/5/2024 on the question of limitation. As it appears from the noting, my lord, this postal tracking report shows that item is delivered, but none appears.
So,
your lordship may fix another date, madam. Because someone might have appeared in the meantime, registered to verify.
Waiting service of notice.
Yes, madam, that
The
item delivered.
When?
Item delivered, it is served.
Just checking.
20th May. And date was fixed 14th June.
Oh, 40 June.
14th June.
28 June. First that IA for dispensing the Peter, this was for the. Okay. Now IA is 7787 of 2023. The postal tracking report indicates that the notice has been served on the sole respondents on 28/5/2024. But as notice has been issued, fixing the returnable date to 28/6/2024, we deem it fit in the interest of justice to adjourn the case to today's 4th to 11/7/2024. Full stop. In the meanwhile, registry shall ascertain if any counsel has appeared on behalf of the 28/6. Now, what date? Make it 18th July. Registry to ascertain if any counsel has appeared on behalf of the respondent. Yes.
Good.
Ketala rising? Already now 5 more minutes. 5 more minutes.
5 more. Solve.
Item 11.
Well, item 11 also, your lordship has issued notice
That's all right.
on 6.
IRL office note indicates that neither notice issued to R1 nor neither the undelivered notice nor the AD has returned back, full stop. List the case on 18/7/2024. In the meanwhile, the postal tracking report shall be placed before us, and registry is also directed to ascertain if any counsel has appeared on behalf of the sole respondent, on behalf of respondent number 1.
Item 12. Item 10, there is a noting mailer. It could not be served.
So you have to ascertain the correct address and
Yes,
take.
madam.
IA for dispensing with SETA dispose of Padave, full stop. 2 weeks time is granted to the appellant to take steps for issue of fresh notice on the respondent number 1 in the question of limitation. IA is an account already. List the case. If requisites with correct address are filed, it is returned unserved.
Yes, madam.
Yes. Unutilized copies be utilized. If postal requisites are filed, notice shall be issued fixing a returnable date. Fixing a returnable date before the of 6 weeks. List the case for the date they do.
20th August.
20 not his.
20.
Yes, 28 है 2024.
Item 13.
Item 13, on 6/4/2024, the
Alright,
notice was issued on the question of limitation.
Here,
Your lordship
2
had
weeks time.
directed to take fresh steps.
You have not taken, that is not
That
noted.
is already taken today.
Acha.
This is the receipt.
Mr. Das, learned additional standing, Saswat Das, learned additional standing, additional government advocate submits that the steps taken when?
But today, my lord.
The fresh steps have been the requisites have been filed today for issuing issue of fresh notice on the respondents. Full stop, office to verify and proceed. Fixing a returnable date on 6
Same date.
weeks,
Right.
same date.
Item 14.
14, my lord, notice was issued on 6/4/2024, but no postal.
Whether it is sufficient and what was the returnable date. So dispensing with disposal of. So notice has been served on the capital respondent. Mr. Das, how many respondents? Sole respondent? They do a notice, if it's sufficient, then they don't give any notice.
One respondent. Sure. One respondent.
Valid service.
Valid service returnable date. Though notice on the matter of condonation of delay has been served on the respondent, sole respondent, there is no appearance on behalf of the respondent. In the interest of justice, list the case on 18/7/2024. In the meanwhile, the registry is to ascertain if any counsel has appeared on behalf of the sole respondent.
Item 15.
15 also notice issued on 9/5/2024.
Are you sure?
My lord. But
Because
there is no.
notice. Fresh condemnation of delay petition is there, no question of further orders. Take a look.
9/5/2024.
Valid service. Same order, 14 and 15, same order.
Lordship, kind permission. There's a matter at 2 o'clock.
We'll come back.
Matter.
We'll come back. We'll come back at 2.
Not,
Okay, 2:30.
No, it's not after reference. Not after the reference. But my lordship knowing it, after reference, votes are not. Never be lordship.
We will seek the lordship's opinion. You make this mention at 12.
Oh, I see.
When that is.
I see. Yes,
I can say about the division of single bench we have sat.
Right.
So, Tanko bench may mention.
Yes.
Next
Acha,
bench,
we reserve it
we'll
for-
mention it in the next bench.
That's for your lordship.
President.
Because normally after the
My lord is head of the institution. He will take care of everything.
No, in fact, in the before 12, when the mentions were being made, I said that I'll seek your lordship's guidance.
Yes, my lord can guide.
All right, we'll see.
Yes, thank you, Lord.
Submission item number 1.
My lord, it is a, my lord, notified. My lord, it is a notified monument of 5th century AD by your lordship's interference in the content proceedings. The developmental work was being carried out, my lord. But page 30, lordship's order in the content proceeding. But while the developmental was being, my lord, undertaken, some miscreants, my lord, have destroyed, my lord, the boundary structure of
What
the.
do you want today?
My lord, in this connection, Annexure 10, though the
What
FIR
do
is
you
lodged by.
want today, Mr. Counsel? Why can't you get a hint? All right.
My lord, the application representation is addressed to reserve the monument from, we have sent to the Director General and Superintending Archaeologist.
You know, Mr. Mohanty, when Lordship Chief Justice is saying something, as a pioneer, I just want to agree with him. I do not express an opinion on this today itself. Whatever he says, I say I agree. Although there is many things to answer it, I don't want to get into that controversy now.
We
Obliged.
will come on Monday.
Monday.
Item number 2. Yes, Mr. Mahapatra.
PIL matter, your lordship. Next week. Next week.
week.
In a PIL matter, he has challenged the order of a revisional authority under the Survey and Settlement Act.
All right.
So that order, which is
Mr. Mohanty can reserve for next week, which I think when asking
Yes.
for next week, why today?
obliged.
Item number 3, you want to save himself.
Obliged.
So item 3, actually, I agreed to argue the matter today. The lordship is sitting.
We are prepared to hear you.
That opportunity.
None that we are prepared to hear you. Argue.
Yes. What is the contempt?
Well, there's a non-compliance of the order
Yes.
by the collector. There is a patch of land, actually a road connecting two hamlets.
Where is it
Honorable Court directed by order date 21/1/2024.
Have you complied the order, Mr.?
No, but it has been listed for the first time. Lordship grant me some time. I will obtain instruction, comply the order. 4 weeks time, your lordship grant will do.
All right. Get this right.
Because the private party has already agreed to give the land.
That's right. What action they have taken,
Correct.
is item 4.
May I please? It's a non-compliance of, my lord. A non-compliance of the order under Annexure 2 passed in WPC No 15091/2019, page 34. The direction for to give the family pension within 3 months. But they have till today, they have not.
You have filed review appeal, that is also rejected.
My friend, I request give a copy because it has not been given.
I have supplied to the central government, so BSNL is a party, so notice.
So we are not.
Notice,
No notice, Mr.
Sosibhushan.
Pierre Bari.
Bari.
Give a copy to him.
Oh, please.
Copy will hand over to Mr. Pierre Bari.
Yes, any other matter?
Just wanted to.
Urgent matter?
No other matter. We'll be missing my Lord Justice Sarangi a lot. And we all hope and pray that your Lordships will have a very good journey there. Of course, 110 is the formal reference. We are not part of it. We are only present there. So just wanted to express that. Grateful
Really,
to
this bar has given
And you also take us in that journey, my lord.
This bar has given me everything.
Yes.
I owe my gratitude to this bar. Each of the members, starting from young member to all senior members, and more particularly senior members, they have taught me how to work, how to do the work. I really deeply obliged to them. If I'm here, it is only because of you and your blessings. Thank you.
Very grateful.
have only one matter.
Yes, but item 22, your lordship had fixed at 2 o'clock. Let's say fix up another date so that.
All right. Only one matter we will take up. And who is for the other side?
22, my senior is there. Sir, your lordship had fixed at 2 p.m. Any day your lordship may fix, but at 2 p.m. if your lordship, as per your lordship's convenience.
Yes. And another matter is item 19. That also.
That's all dates.
State wanted also time in 19.
Yeah, let's make almost. May I prefer next week?
We will see.
Well.
Time date.
What is that one? Oh.
Item 55.
No, there was one before that.
Item 7.
7 and 55.
Item number 7.
Item 7 and 55, I am forwarding the order from the Honorable Apex Court.
Is there any such order?
Lord, I have.
In one transfer applications,
Lord, let me see this, my lord, the chart. I have given.
kindly see. The two sets, my lord. So for this transfer application is concerned filed by the National Testing Agency.
My lord, there are a total of 4 transfer petitions. On the first page, your lordship of the index, lordship will find I have culled out, my lord, the transfer petition numbers, the Honorable High Court from which the transfer is sought for, and the PIL numbers or the writ petition numbers before the Honorable High Court. Now, if your lordship takes page 2 of the downloaded copy of the order of the Honorable Apex Court, page 2 deals with the transfer petitions, which my learned friend is referring to, my lord.
Is there any order passed by this?
My lord, may I place that page 2, my lord, that part where the transfer petitions are referred to?
That is NTA filed the transfer application 1602 by 2020.
Posted to 8.
That is posted to 8.
My lord.
And the further proceeding has been stayed.
The
language, your lordship. Yes, yes.
The language reads, my lord, TP number 1 to, there are 4 transfer petitions.
Yes, we understand.
My lord. It says, in the meantime, further proceedings before the High Court shall remain.
Yes.
This is the High.
My humble submission would be relates to those respective Honorable High Courts, my lord. That is my first submission, my lord. My second submission is, my lord, the matter in issue in those petitions.
We understand.
My lord, is not the same.
We understand. The question is that even if your case is different from what is there before the Supreme Court,
my lord,
do you have any merit? Let us see.
My lord, I'm deeply
Let us
obliged.
examine.
I'm deeply obliged.
Today, my lord, there are 4 number of writ applications. So far, 3 number of writ application in item 55 and item 7. They are regarding their prayer is they got less marks. They demanded more marks. So far, my learned senior's case is concerned. Here is a different case. He says that in one question number, though he has corrected the answer, but wrong number has been given.
So this is
My lord, may I place what is my issue, my lord? My issue, my lord, is primarily 2, my lord. One, question number 26.
Yes.
My lord, the NTA provides, my lord, a timeline in which I can raise an objection. I raised the objection before the NTA. Now they dealt with one of my objections, and that engages your lordship's attention at page 49 of your lordship's brief. Page 49, my lord.
WBC 14277.
287, my lord.
87.
287.
14287.
The second one, which is tagged with that.
The third one, my lord, I think.
Item number 50?
55.
55, second one.
Second one.
Om Amrit Mahanti, 14287.
Yes.
Your lordship takes, my lord, I raised the grievance according to the procedure provided.
Yes.
Grievance 1 is dealt with at page 49.
Yes.
Wherein the NTA, my lord, this is, I'm referring to paragraph 3 in the middle of your lordship's page, my lord. NTA received 13,300. Lordship has got that?
Page?
Page 49 of your lordship's brief, my lord. Towards the middle.
Yes.
There is a, my lord, caption number 3 serial.
Yes.
Second para thereof, my lord. NTA received 13,373 challenges to the provisional answer key of one question in physics. Due to the differences in the old and new editions of the NCERT book, the subject expert held that 2 opinions be taken as correct in place of one option for this question. Out of the 67 candidates who got 720 out of 720, 44 are on account of the revision in one answer key of physics, and 6 are on account of compensation for marks lost due to time. That has already been answered by the Honorable Apex Court vis-a-vis the compensation for marks. But this physics issue, my lord, this is how they dealt with my grievance.
What is wrong in it?
My lord, the next grievance I had raised was, my lord, if your lordship takes, my lord.
No, what is wrong in it? What is wrong
No,
in
I have, my lord, instead of one correct answer, they said the options can be 2.
Yeah.
I fall within one of those, so I received the marks there.
Yes.
Now, in the last one wherein I have an objection, if your lordship peruses the questions, none of the answers are correct.
We cannot do that.
I am obliged, my lord. Therefore, my lord, the test of most probable answer will come in. And the NTA has not dealt with that. My only prayer is, my lord, let the NTA deal with that. That's all.
No. We will not enter into that. There must be an end to these processes.
My lord, it has to be sent to the expert committee. I have raised
No, we will not send. Matter was already sent to the expert committee.
This was not, my lord.
Which was not?
The part where I raised regarding botany was not sent to the expert committee. The expert committee has not dealt with that because this is the press release of the expert committee.
Let them file affidavit.
My lord, my only prayer is let the expert committee.
No. We will not issue direction. We will not do that.
They may do it on their own if it is
Unnecessary.
permissible.
Then there will be 1 lakh experts committees constituted by the High Court for each of the questions.
No, they already have one. Committee. Let it go to that.
We will not do that.
Let them file.
Very well.
They might do it on their own.
Very
That
well.
is the procedure. Why should we?
We don't interfere in such matters. File affidavit.
My lord, your lordship grant 2 weeks time and file.
The NTA to file counter affidavit.
Because question of admission. why
10
should
days,
the
10 days,
NTA
10 days. 10.
As early as possible. That's my almost
10 days, your lordship grant 10 days time.
2 weeks.
My obliged.
Item 7, my lord, is something different. Item 7 is something different, my lord. I have prayed in this petition that as per the answer sheet, my lord, given by the petitioner, which was supplied by the authority to the petitioner, and the answer key supplied by the opposite party, there are different marks have been allowed to the petitioner. Instead of 630, the petitioner has only got 284.
Yes. All these cases may be tagged together. After within 2 weeks, we will file affidavit in all cases, my lord.
File your.
So you who is appearing in what? Please give us slip.
Yes.
We're deeply grateful for having taken up the matter.
Obliged, ma'am.
Come.
Take up tomorrow. That's State Bank. Bank matter. Bank matter.
Tomorrow is single by
Monday.
Okay, Tuesday.
Next.
Deeply blessed.